Welcome to Chapter 12 of Criminal Procedure. This chapter is called The Initiation of the Legal Process, Bail, and the Right to Counsel, and it covers three of the most important pillars of pretrial criminal procedure. We begin with prosecutorial discretion, the enormous power that prosecutors hold in deciding who gets charged, with what crime, and whether to pursue a case at all. We then move to the mechanics of what happens after arrest. The probable cause hearing, the first appearance before a magistrate, and the bail decision. The chapter closes with one of the most important rights in American criminal justice, the right to counsel under the Sixth Amendment. As you work through this chapter, keep one central question in mind. What does it mean for the criminal justice system to be fair to individuals who are presumed innocent? That question runs through every topic we discuss today, from the prosecutor's discretion to the conditions of pretrial detention to whether a poor person can get the same quality legal representation as a wealthy one. Let me walk you through the 10 learning objectives for Chapter 12. Objective 12.1 covers prosecutorial discretion, the broad power prosecutors have and the narrow circumstances in which courts will review their decisions. Objective 12.2 covers bail, what it is, what it's for, the Eighth Amendment limits on it, and the ongoing national debate about whether the cash bail system is fundamentally unfair. Objective 12.3 covers the constitutional rights of pretrial detainees, people who have been arrested but not yet convicted. These individuals retain constitutional rights but are subject to reasonable institutional regulation. Objectives 12.4 through 12.8 form the core of the chapter on the right to counsel, the right to appointed counsel, when it attaches, what it offers, what offenses trigger it, how indigency is defined, and whether defendants get to choose their lawyer. Objective 12.9 covers effective assistance of counsel, not just having a lawyer, but having a lawyer who actually performs competently on your behalf. And Objective 12.10 covers the right to self-representation, the constitutional right to represent yourself, its limits, and when courts can deny it. Let's begin with prosecutorial discretion, which Justice Robert Jackson famously called the most powerful position in the criminal justice system. After a suspect is arrested, the case shifts to the prosecutor. The prosecutor decides whether to charge, what to charge, whether to plea bargain, and whether to divert the defendant to a treatment program. Courts have recognized broad prosecutorial discretion for three reasons. First, separation of powers. The prosecutor is in the executive branch, charged with faithfully executing the laws. Judges in the judicial branch are reluctant to second-guess the daily decisions of the executive, absent a clear constitutional violation. This isn't just judicial modesty. It reflects the constitutional structure of American government. Second, discretionary judgment. A prosecutor weighs the strength of the evidence, the likelihood of deterrence, the department's enforcement priorities, the circumstances of the case, and the defendant's background. Courts acknowledge that they simply do not have the expertise or the context to evaluate how prosecutors weigh and balance all of these factors. Third, resources. If every charging decision were subject to judicial review, the system would grind to a halt. The presumption is one of regularity. Courts presume prosecutors honestly and fairly exercise their authority. But discretion is not unlimited. Two constitutional limits apply. Selective prosecution violates the Equal Protection Clause. The two-pronged test from Waite v. United States requires both a discriminatory effect, the prosecution targets members of a protected class, while leaving similarly situated non-members unprosecuted, and a discriminatory purpose, which is a very high bar. In the Turner crack cocaine case, statistics showing no white defendants were charged was insufficient because the data reflected the demographics of the actual distribution network rather than prosecutorial discrimination. Vindictive prosecution violates the Due Process Clause. In Blackledge v. Perry, the prosecutor responded to the defendant's assertion of his right to a new trial by upgrading the charge from misdemeanor to felony. The Supreme Court held this was presumptively vindictive, but, and this is important, the court in Goodwin held that a pretrial decision by a new prosecutor to bring additional charges after the defendant refused to plead guilty is not presumptively vindictive. Prosecutors are allowed to continue assessing their case and to charge more seriously if the facts warrant it before a trial begins. Now, let's walk through the sequence of events that follows an arrest, because this procedural sequence is the foundation of everything that comes thereafter. When a person is arrested without a warrant and without a prior grand jury indictment, the first thing that must happen, constitutionally, is a determination of whether there is probable cause to continue holding them. The Supreme Court in Gerstein v. Pugh established that the Constitution requires a judicial determination of probable cause as a condition for any extended restraint of liberty. This hearing is non-adversarial. It does not involve the full procedural apparatus of a trial, but it must be prompt. In County of Riverside v. McLaughlin, the court gave the word prompt a concrete meaning: 48 hours. Within 48 hours of arrest, the government must bring the suspect before a judicial officer for a probable cause determination. That 48-hour period exists to allow the police to complete legitimate administrative steps: booking, fingerprinting, photographing, record checks, and so on. It is not blank time that can be used to gather additional evidence or to wait for convenience. The rule has teeth. If the government delays beyond 48 hours, the burden shifts to the government to demonstrate a bona fide emergency or other extraordinary circumstance. Intervening weekends do not qualify. In Riverside County's case, their practice of excluding weekends and holidays meant that people arrested on Thursday could sit in jail until Monday, nearly 5 days, without a probable cause determination. The Supreme Court said that is unconstitutional. Justice Scalia's dissent argued that even 48 hours was too long, that the historical common law tradition demanded a prompt hearing, and that innocent people are the primary beneficiaries of prompt judicial oversight. His 24-hour standard was not adopted, but his concern for the innocent arrestee is a powerful one worth thinking about. The first appearance serves 4 purposes: informing the defendant of his charges, advising him of his constitutional rights, including Miranda, making a bail determination, and appointing a lawyer for indigent defendants. In many jurisdictions, the Gerstein hearing and the first appearance are combined into a single proceeding to conserve judicial resources. The right to bail and the question of preventative detention are central to this chapter, and the tension between individual liberty and community safety is at its sharpest here. Bail's historical purpose is to ensure that defendants appear for trial. An individual should not be locked up before being found guilty. The money deposit serves as an insurance policy against non-appearance. The Eighth Amendment provides that excessive bail shall not be required, and in Stack v. Boyle, the Supreme Court held that bail set above the amount needed to ensure the defendant's appearance is excessive. The money bail system has been under sustained criticism for decades. The core problem is simple. Wealthy people can post bail and go home to prepare their defense. Poor people sit in jail. Studies show that detained defendants are more likely to be convicted and more likely to receive harsher sentences, not because they are guiltier, but because they are unable to prepare on adequate defense. The cases of Khalif Browder and Sandra Bland, both of whom died after pretrial detention they could not afford, illustrate the human cost of a bail system that treats financial resources as the measure of freedom. Reforms have been significant. The Federal Bail Reform Act of 1984 moved away from money bail and toward release on recognizance or unsecured appearance bonds as the default. Illinois has abolished cash bail entirely for most offenses, replacing it with individualized risk assessments. Courts in Harris County, Texas, and California have found that predetermined bail schedules that don't account for the defendant's ability to pay violate equal protection and due process. Preventative detention is a separate and more controversial matter. In United States v. Salerno, the Supreme Court held that the Bail Reform Act's provision for pretrial detention of defendants who pose a danger to the community is constitutional. Salerno and Cafaro were high-ranking members of the Genovese crime family charged with murder, conspiracy, among other crimes. The court held their detention was regulatory rather than punitive. It served the government's compelling interest in community safety, not the punitive goal of punishment before conviction. The court's reasoning on due process has two parts. On substantive due process, is this even permissible? The court held that preventing danger to the community is a legitimate regulatory purpose and that the detention is not excessive relative to that purpose. On procedural due process, is the process fair? The court pointed to the right to counsel at the hearing, the right to present evidence and cross-examine witnesses, the clear and convincing evidence standard, and the right to immediate appeal. Justice Marshall's dissent is one of the most powerful passages in the chapter. He argued that an indicted cannot be evidence of guilt. And if after acquittal the government could not continue to detain the defendant as dangerous, it makes no sense to detain them before trial when they are presumed innocent. Marshall saw preventative detention as a fundamental assault on the presumption of innocence. Whether you agree with the majority or the dissent, the tension is real and important. The development of the constitutional right to counsel is one of the great stories of expanding civil liberties in American history, and Gideon v. Wainwright is at its center. The story begins in 1932 with Powell v. Alabama, the Scottsboro Boys case. 8 young black men were accused of raping 2 white women on a freight train in Alabama. They had no lawyers until the day of trial, and the men who were nominally appointed to represent them were either unfamiliar with Alabama criminal procedure or had virtually no time to prepare. The Supreme Court held that under the specific circumstances, a capital case in which the defendants were unable to represent themselves, due process required the appointment of counsel. It was a narrow holding, but it established the foundational principle that effective legal representation is essential to a fair hearing. In 1938, Johnson v. Zerbst extended the right to counsel to all federal criminal prosecutions. The court's language is memorable and worth knowing. Even an intelligent and educated layman, left without the aid of counsel, may be put on trial without a proper charge, convicted on incompetent evidence, and may fail to establish his innocence simply because he doesn't know how. The court called counsel the guiding hand that defendants need at every step. Then came Betts v. Brady in 1942, which retreated from this logic. The court held that states were not constitutionally required to appoint counsel for indigent defendants in every felony case, only in special circumstances. The deciding vote was cast by a judge who thought Betts, a 43-year-old man with prior criminal experience, was intelligent enough to represent himself. This decision was widely criticized by legal scholars as inconsistent with the principles established in Johnson v. Zerbst. Gideon v. Wainwright in 1963 overruled Betts and established the right that we now take for granted. Clarence Gideon was a 51-year-old drifter charged with breaking and entering a pool hall in Florida. He was denied a lawyer, conducted his own defense, capably for a layman, and was convicted anyway. His handwritten petition to the Supreme Court launched one of the most important civil rights cases in American history. Justice Black's opinion is powerful in its simplicity. Any person too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided. Governments spend vast sums of money to prosecute. Defendants who can afford lawyers hire the best ones available. This universal recognition that lawyers are essential, not luxuries, means that the legal system cannot deny them to the poor without creating a fundamentally unequal justice system. The right to counsel established in Gideon raises 2 follow-up questions that the Supreme Court has had to answer in subsequent decisions. When does the right attach, and for what offenses does it apply? On timing, The right to counsel attaches when formal adversarial proceedings begin, at indictment, information, arraignment, or preliminary hearing. Before that point, the defendant is still a suspect rather than a defendant in the formal legal sense. After that point, the right to counsel applies at all critical stages of the prosecution. A critical stage is any phase of the prosecution that might negatively impact the defendant's ability to present a defense at trial, and at which the presence of an attorney would safeguard the defendant. The standard formulations are procedures that would impair defense on the merits if the accused proceeds without counsel, or any stage where the counsel's absence might derogate from the right to a fair trial. Post-indictment lineups, custodial interrogations, preliminary hearings, arraignments, plea bargaining, trial, and sentencing are all critical stages. Photographic arrays, DNA swabs, handwriting exemplars, and pre-indictment lineups are not. On which offenses? Gideon itself applied to felonies, but what about misdemeanors? What about offenses where the only punishment is a fine? Argersinger v. Hamlin in 1972 extended the right to any offense, whether petty, misdemeanor, or felony, where actual imprisonment results. No person may be imprisoned for even 1 day without having been represented by counsel. The court reasoned that misdemeanor trials can be just as complex as felony trials, and the absence of counsel creates pressure on defendants to plead guilty without understanding their rights. Scott v. Illinois in 1979 drew the other boundary. There is no constitutional right to appointed counsel in prosecutions where only a fine is imposed, even if imprisonment was authorized under the statute. The actual penalty, not the possible penalty, determines whether counsel was required. Alabama v. Shelton in 2002 addressed the in-between case, suspended sentences. The court held that a suspended sentence that might lead to imprisonment in the future requires that counsel was provided at trial, even though the defendant did not actually go to prison. The constitutional protection looks forward to potential future imprisonment, not just the sentence imposed on the day of conviction. The Sixth Amendment doesn't just guarantee the presence of a lawyer, it guarantees the effective assistance of a lawyer. The landmark case establishing this standard is Strickland v. Washington from 1984. The case involved David Washington, who had pled guilty to 3 murders, torture, kidnapping, and theft. His attorney decided that the best strategy at sentencing was to argue remorse and acceptance of responsibility rather than to investigate and present mitigating evidence. The judge sentenced Washington to death. Washington claimed his lawyer was ineffective in not seeking a character witness or requesting a psychiatric examination. Justice O'Connor's opinion established the 2-pronged test that governs ineffective assistance of counsel claims to this day. The first prong, deficient performance, requires the defendant to show that the lawyer's performance fell below the objective standard of reasonably effective legal representation. Courts look at the totality of the circumstances and maintain a strong presumption that the lawyer acted competently. Strategic choices are generally protected. The standard is reasonable performance, not perfect or even optimal performance. The second prong, prejudice, requires showing a reasonable probability that but for the lawyer's errors, the results would have been different. This is a probability standard, not a more likely than not standard, but it must be enough to undermine confidence in the outcome. What does the case law tell us about when lawyers are and aren't effective? Lawyers are ineffective when their ignorance of the law affects the outcome, as in Kimmelman, where an attorney failed to file a suppression motion because he didn't know the pretrial discovery rules, or Hinton, where an attorney wrongly believed he had only $1,000 for an expert witness, leaving an innocent man on death row for 30 years. Lawyers are ineffective when they fail to investigate mitigating evidence in death penalty cases, as in Wiggins, Rampilla, and Porter, where defense attorneys made little or no effort to uncover histories of abuse, mental illness, or military service that might have moved juries toward a life sentence. Buck v. Davis is particularly important. Defense counsel called a psychologist who testified that the defendant's race was a factor that increased his likelihood of future dangerousness. Chief Justice Roberts held that no competent defense attorney would introduce such evidence about his own client. The evidence said, in effect, that the color of Buck's skin made him more deserving of execution. Both prongs of Strickland were satisfied. The performance was deficient, and there was a reasonable probability that the racially charged testimony affected the jury's future dangerousness determination. In contrast, strategic choices that have a rationale behind them about which witnesses to call, how extensive an investigation to conduct, whether to focus on guilt or sentencing, are generally upheld, even if the outcome was unfavorable. The final two topics in this chapter, self-representation and indigency standards, round out the picture of the Sixth Amendment right to counsel. On self-representation, in Ferretta v. California in 1975, the Supreme Court held that the Sixth Amendment includes the right of a criminal defendant to represent themselves at trial. This might seem counterintuitive given Gideon's emphasis on the necessity of legal representation, but the court grounded it in the autonomy principle. The Sixth Amendment was designed to protect defendants from an unwanted lawyer as much as to ensure access to one. Justice Blackmun's dissent colorfully noted that the decision formally recognized the constitutional right of an individual to make a fool of himself, but the majority held firm. The Ferretta right has three limitations. First, the defendant must give timely notice, not a last-minute request designed to delay the trial. Second, the defendant must be competent. They must knowingly and intelligently waive the right to counsel and must be competent to stand trial, though they need not have legal training. Third, disruptive defendants forfeit the right. Indiana v. Edwards in 2008 added an important gloss. Even a defendant found competent to stand trial may be denied self-representation if severe mental illness prevents them from conducting trial proceedings themselves. The constitutional right to self-representation is not absolute. States may protect both the defendant and the integrity of the proceedings by requiring counsel for those who cannot competently conduct their own defense. On indigency standards, courts have not imposed a uniform federal standard for what makes someone indigent enough to qualify for appointed counsel. The typical state standards look at whether the person receives public assistance, whether income is at or below 125% of the federal poverty level, or whether the person cannot afford the anticipated cost of defense. Courts may also consider extraordinary circumstances like medical expenses or child support. Indigent defendants do not have the right to a specific appointed lawyer. If their assigned public defender is unavailable, a new one can be assigned without their consent. There is no constitutional right to a meaningful attorney-client relationship in that sense. Non-indigent defendants, however, do have a Sixth Amendment right to the counsel of their choice. A wrongful denial of that right is automatic reversal. No harmless error analysis. And in Louise v. United States, the court held that the government cannot freeze untainted assets, money not connected to the crime, that the defendant needs to pay their chosen lawyer. The right to counsel of choice would be meaningless if the government could strip defendants of the resources to exercise it. Finally, the Padilla Doctrine requires that counsel advise non-citizen clients of the deportation consequences of a guilty plea. Deportation is the equivalent to banishment or exile, and a lawyer who fails to address this is providing ineffective assistance of counsel. Let me bring Chapter 12 together with the 6 key takeaways. First, prosecutorial discretion is broad, but constitutionally limited by the prohibitions on selective prosecution, requiring discriminatory effect and discriminatory purpose, and vindictive prosecution, requiring a realistic likelihood that the charging decision retaliates against the defendant for asserting their rights. Second, the probable cause determination must occur within 48 hours of arrest under County of Riverside v. McLaughlin. The first appearance serves 4 purposes: notification of charges, advisement of rights, bail determination, and appointment of counsel for indigent defendants. Weekend and holiday delays do not excuse violations of the 48-hour rule. Third, bail's primary purpose is to ensure appearance at trial. Anything beyond that is excessive under the Eighth Amendment. Preventative detention is constitutionally permissible under the Bail Reform Act when the government proves by clear and convincing evidence in an adversarial hearing that no conditions of release can protect community safety. But the cash bail system's discriminatory effect on poor defendants has generated significant reform momentum across the country. Fourth, Gideon v. Wainwright established that indigent defendants charged with felonies have a constitutional right to appointed counsel. The right extends to any prosecution where actual imprisonment is imposed, regardless of the offensive classification, but it does not apply where only a fine is imposed. The right attaches at the initiation of a formal adversarial proceeding and applies at all critical stages thereafter. Fifth, the Strickland two-pronged test governs ineffective assistance of counsel claims. Deficient performance plus prejudice must be shown. Courts are deferential to strategic choices, but will find ineffective assistance where lawyers ignore fundamental legal knowledge, fail to investigate clearly relevant mitigating evidence, or, as in Buck v. Davis, introduce evidence that their own client's race makes him more dangerous. In cases where counsel entirely fails to subject the prosecution's case to adversarial testing, prejudice is presumed. Sixth, the Sixth Amendment provides a right to self-representation that can be denied to defendants with severe mental illness who cannot competently conduct their own defense. Indigency standards vary by state. Non-indigent defendants have the right to counsel of their choice, and the government may not freeze untainted assets needed to exercise that right. That concludes Chapter 12. Thanks for watching, and I'll see you in the next lecture.